the light at the end of the tunnel. It's a phrase that often is used to suggest that you're reaching a glorious destination that you've been waiting for or striving towards for some time. I'm not really sure it's appropriate in this sense from our perspective. It probably is, though, if you're a downtrodden data subject who's been being maligned or abused in some way through data usage for some time. The new data regulations, the Data Protection Act Mark II, if you like, the Gdpr, comes along and hopefully will alleviate some of those issues for you. For those of us in this room, often involved in the marketing world, it's not quite so clear-cut. It's going to cause a whole load of pain and a whole load of preparation needs to be done. If you're not ready, then the light at the end of the tunnel is probably a train that's steamrolling towards you as we speak. So, the rather dull and dreary title, GDPR, the General Data Protection Regulations, is in fact an EU piece of legislation. Just because of Brexit, I'm afraid, that doesn't mean to say we don't have to embrace it and love it, we still do. It's gloriously called Regulation 679. It's one of those things we can forget almost straight away. We can't forget, though, that it's going to be hitting us on the 25th of May 2018. It is in fact already in UK law. It was brought into law nearly a year ago. But this is when it gets its teeth, and from this moment on, that's when you'll find that people start getting fined for doing things wrong. And if you haven't already heard about it, the fines and so forth are rather scary. So I'm afraid I'm the bearer of bad news for those of you who haven't heard about it already. The reason it's necessary is that the Data Protection Act is a little bit old, a little bit long in the tooth itself. It was formed originally in 1995 and it's been amended a couple of times since, but the world didn't look like it does today. Computers and laptop computers and so on were rather clunky old things that could barely do the jobs that we would imagine possible today. Mobile phones looked like bricks instead of little computers in your palm, and cookies were the type of thing that chap in the middle would have had. Nowadays, the world has moved on a lot. It's worth remembering that in 1995, Google wasn't even created. So the world has moved on an awful lot since then. We've now got things like Facebook, like Google, like Anonymous and other forms of hackers and activists. We've got portable memory sticks, which you can disguise if you want to with something the size of approximately a thumbnail and carry around library loads of information, something that wasn't at all feasible in 1995. We've also got CCTV, drones, all sorts of other strange things. So to cope with some of the new realities, things like Facebook stalking, revenge porn, all of those slightly awkward things, there's a whole load of things that are changing. The first one, and this has a bearing on all of us, is that the definition of what is personal data has changed, and it now is going to extend to include people who are involved in the B2B sector in a much more direct way than it used to. It used to be the case that if you were trying to do business-to-business marketing, you could argue that the data subject at the far end was an extension of the company they worked for, and so they kind of didn't have any personal data rights because they weren't really a person. They were a limb of a company. That's not the case anymore. Under the new regulations, if it can identify a person, it's personal data, and so that applies just as much in the B2B world. It in fact has stretched personally identifiable information, or the idea about what constitutes personal data, even further to include genetic information, online IDs, which might include email addresses, social media handles, IP addresses, a whole host of things. Your photographs of people's faces, number plates, anything which will allow you to laser back into one individual means it's personally identifiable data, which means that the rules apply to everything you then do with it. And the rules bring some enhanced data subject rights. By the way, I hope you noticed, because you're all marketing people, I've coloured them in for you, because I thought, you like colour. But it brings some enhanced data subject rights. I will quickly go through those in just a minute, but suffice it to say that they're small, subtle changes, but they do change just how significant you need to treat the data and how carefully you need to treat it to make sure you don't stamp on their toes. One of the more obvious changes, though, is that subject access requests, this is the right to access, it's one of the rights in the Act, just like it was under the Data Protection Act, you could submit a subject access request to find out what information was held about you. But there are a couple of small changes now. One is that you have slightly less time to respond to a subject access request if somebody asks for their data. And the other one is you now can't charge. And that little business with not being able to charge is such a small change but it has the potential to have huge implications. It used to be the case that you could levy a small, reasonable charge, and commonly it was nothing, but it might have been £5 or £10, depending on your organisation. Now it has to be free, or from May 2018, it has to be free. And the likelihood is that whilst that may give you a little bit less money coming into your organisation, the bigger issue is it means there's no disincentive for somebody. If somebody historically was mildly interested in the data you had about them, then in actual fact, they had to at least be interested enough to be prepared to pay a £10 fee. Now they can be mildly interested and just pop in a subject access request with absolutely no reason not to. So there's two things. One, you're likely to get more of them in your organisation, more people requesting to know what data you have. And the second one is, they actually become something which is borderline weaponizable if you want to, or if somebody wants to. If you can imagine, for instance, you were BP, and it was just after you poured lots of oil all over some ocean somewhere. Imagine if Friends of the Earth all got together and 250,000 people sent in a subject access request simultaneously, all of which were free and all of which you had only 1 month to be able to respond to. In that instance, BP had better be very sure their systems were robust enough to react and to respond and to serve that data back very quickly. I think that's only an issue for companies who perhaps are in the front line, somebody who does have an ethical stance or something that they need to protect against, but nonetheless, for some people it's a very big issue. There's another requirement, which is that you must conduct very formalised DPIAs, impact assessments, if there's any significant risk to the data subject. Clearly that might involve things like health data and so on, but if you have data about somebody which could expose them to significant risk if it was leaked or used in the wrong way, then you need to conduct a very sensible and very structured DPIA that takes quite a while. It's quite detailed, but it does mean that you thought through all of the wrinkles that you need to think through to properly look after those data subjects. It's risky to export data. It's not to say you can't, but I literally mean export as into other territories. The Data Protection Act and now Gdpr has a coverage which is EU-based. The idea is if you're doing anything with data in the EU, so if you're a data controller in the EU, or if the data subject is in the EU or from the EU, then in actual fact it applies. The problem is if you send the data to, let's say, India, because they're a call centre that's doing work for you and they're doing it relatively cheaply, then you're trusting that their protection of the data is going to be as robust as somebody in the EU. And now, the bad news is if you choose to do that, that becomes your responsibility. Okay, utterly. It doesn't matter how good or bad they are in India, if you've chosen to send it to them, it becomes your responsibility if one of their junior staff sells it on the internet. The concept of consent is much more robust. You will all have heard much about this if you're at all aware of GDPR. Consent has changed quite a lot here. It needs to be positive, so it can't be a pre-ticked box. It needs to be something that they definitely tick themselves from empty to full, if you like. It needs to be clear and unambiguous. It needs to be properly informed decisions. So they're actually saying, yes, I truly want this person to send me their marketing, if that's the issue that's at the consent there. In actual fact, I would suggest that consent isn't, for most of us, the right way to treat data. It certainly isn't the recommended way by the ICO or by Working Party 29, which is the European Union version of the ICO. The idea is that consent is almost the last resort when everything else has failed. But you wouldn't necessarily understand that if you've been reading the marketing press recently, which seems to have focused very heavily on the changes to consent. If you are going to rely on consent, though, it's very important that you check that your consent mechanism is fair, unambiguous, clear, positive action, affirmative, freely given. Freely given means you can't induce them. So you can't, for instance, enter them into a competition if they give you their data, because by not giving you their data, they couldn't enter the competition, so you kind of bribe them for it. So you can't induce this, you have to be literally making an educated judgment that they want you to have their data and use it in this way. You have an obligation to prevent personal data breaches. There's obvious issues around data security and hacking and virus firewalls and all sorts of things like that. You have to make sure you do it justice. At the very least, I would suggest you look at Cyber Essentials if you haven't already done so. It's a fairly straightforward way. Cyber Essentials or Cyber Essentials Plus is a fairly straightforward way of doing kind of the bare necessary foundation amount of data IT type security. You have to make efforts to detect a breach. So even though you may have tried to prevent it, if there is one, you have to try and figure out that it's happened. And the reason you have to do that is because there's another obligation on you to tell people if there's been a breach. You have to advise them because the implications on them might be quite serious. It might be that they lose money or that their house gets burgled while they're on holiday or any number of other things. So when you're aware of a data breach, there's an obligation on you to tell people. Probably the ICO, probably the data subjects, although both of those depend to some extent on just how risky and how exposed the data subjects are as a result of the breach. Making efforts to detect the breach is quite tricky. You need to understand where your data might be being used and how it's used to be able to figure that out, and that changes from situation to situation. But it's quite tricky to figure out how you understand when somebody has a copy of your data that they shouldn't have done. One way might be to have a seed company in there, a seed record, so that you can get the mailing at home, and the only person who should write to you at that address would be you. But when you see somebody else, that's an indicator it's got out in the world. There's now a joint liability between processors and controllers. So a controller is perhaps yourself. It may be a company that owns the data in the form of a client list, and they want to keep processing it to keep remarketing to it. A processor may be a mailing house or an advertising agency who's going to use the data to do some service, some treatment, and to deliver some great step forward. There's no joint liability. So if you're a mailing house, what that means is when you're working with the data that your loving customer has given you, you're responsible for whether that data was collected legally. And if it wasn't, if they've cocked it up somewhere, you're responsible for that. The same is true the other way around. If you are in fact a company with a client list and you're wanting some marketing company to do some services for you, you're now responsible for how well they do that. And it's no excuse saying you didn't know and how could you have known. It's your job to know, but we'll come back to accountability in just a minute because it gets rather scary. Sorry, I feel a bit like the person who's stolen Christmas here. This is a rather dry subject, and it's quite a scary one if you're not aware of it. I make no apology for actually painting it in fairly bleak terms, because you do need to pay attention to it, and if you haven't done yet, do start now. The burden of proof has moved. This is a strange sentence. What it actually means, though, is you're guilty until proven innocent. If you've been treating data, you must be able to prove to a judge, if necessary, that you are, and that the actual quoted phrase is, in no way responsible. So you have to be able to prove that you're in no way responsible. If you can't prove it, then you're guilty. It's a very unusual bit of law, but there it is. And all of that is underlined by, and kind of emphasised by, easier and much stronger enforcement. That actually doesn't quite exist yet, but it's going to. It's going to provide a way people can complain online at the click of a button in about 10 seconds by saying, I feel aggrieved, I am a data subject, that this person has impinged my rights. And the idea is that then it will automatically move to an enforcement action. So there's no reason not to complain if they feel that they've got a case. And there's also some reasons why they might choose to complain now. One, if they're trying to be awkward to you. But in fact now there's class actions specifically allowed. So this is the type of law case that we all know in America where 100 people might club together and take an action for smoking damages or something, and at the end of it everybody gets massive payouts multiplied by everybody who was signed up to the action. So imagine if you're part of a customer list who's all been marketed to inadvertently or badly and everybody takes a class action together. I can assure you there are already about a dozen legal practices here in the UK who are specifically gearing up their solicitors and their lawyers ready to commence these, and they're intending to start advertising recruiting claims. So they're doing a sort of a no-win, no-claim type process on it. Personal damages are available, and not just damages as in I lost my house and that's very awkward and expensive, but actually non-material damages too. So if it makes somebody feel sad or stressed, that's just as significant and they're entitled to damages. And there are huge administrative fines, and I'll mention the numbers for you, but it's 20 million euros or 4% of your annual global turnover, whichever is the greater, which is an unusual phrase to say whichever is the greater, but here we are. As you can imagine, this is eye-wateringly large sums. It's sort of ending a business type sums for many, many companies. Just to put it in context, recently you have all heard about a year ago about TalkTalk, for instance, who got fined 400,000 for the data breach that they had. You may have remembered seeing Dido Harding standing in front of the new cameras talking about what had happened and what they were hoping to do about it. Well, in actual fact, 400,000 compared at the time with the largest fine that was possible under the Data Protection Act of £500,000. The largest fine now would be 20 million. So if you just assume it's the same 80%, that's a €16 million fine for TalkTalk, potentially under the same regime. But in fact, TalkTalk's turnover is bigger than that, and their 4% of annual global turnover would have meant that they were significantly more than that. Something in the order of 73 million would have been the possible impact of the fine on them. And that's before you start on class actions, personal damages, or anything else. Okay, I've gone black and white for a minute. It's a bit legal. Okay, so GDPR relates to personal data, but the idea about what is personal data has changed. It's a little bit more all-encompassing. If it can identify a person, it's personal data. It applies whenever, and this is such a long list, it means whenever anybody has their details in a list. Basically, it's if the data subject is in the list, or if the controller is in the EU, or if the processor is in the EU, or if the processing is in the EU, then it's covered by the legislation. So you might assume that you could actually get around some of this by getting all your email broadcasting done by somebody in Karachi. Well, you can't, because you are the ultimate beneficiary, and so you're still the person who's responsible for it, and you're the person who would be chased by the ICO for it. Processing of sensitive data is largely prohibited. You can do it, you just have to be particularly careful, and you have to have gone through many extra safety nets to make sure you're doing it sensibly. Processing data relating to children has additional requirements, most notably in the area of consent, but there are others as well. It's to do with the fact that some children wouldn't understand the words you're using to them. If you're telling them what you're going to do with their data, they may not be equipped to understand all of that phraseology. And so you need to make sure that you've made it clear to them in a language that they will understand, and potentially you need to have got the consent of their adult, parent, whatever. And you must be able to demonstrate that you satisfy the principles. This prove that you're in no way responsible. You have to be able to demonstrate that you satisfy the principles. So one of the themes that goes through this is, I'm afraid, you have to do something rather akin to a health and safety book. You have to have lots of documentation and policies to say what you do and what you don't do with data, so that A, nobody goes wrong and nobody steps out of line, but also B, if you do get called into court, you could produce all of these documents and say, no, we were really being careful, this is what we do and this is why we do it. Back to colour. So, the first principle, lawful, fairness and transparent. Lawful is to do with having a good reason to be working with the data, and there's only 6. For people in the commercial world, most of them don't apply because there's things for doing business on behalf of the state. So if you're a police force, there's all sorts of things which they can do under 1 or 2 headings. But for us, there's really just 3. One is for the completion of a contract. So imagine you're signing somebody up to use a mobile phone. You need to be able to process their data to be able to deliver the phone calls to them and deliver the bill. It's part and parcel of fulfilling the contract. Another one is because they've consented, as I suggested. That's changed a little bit, and if you are relying on it, then make sure you're doing it right. And the other one, which really stands out, is legitimate interest is one of those things which says you can process the data because what you're doing isn't illegitimate, it's not illegal, and it's of benefit to you. You need to do it, it's going to be helpful to you, perhaps even just as little as making a profit. Those are the 3 which particularly stand out as relevant to most commercial companies, and for some of you, if you're in, for instance, scientific screening, it may be that some of the slightly more state-sided ones would apply as well. There is a purpose limitation, so you must only use the data for what you intend and document that you're intending to use it for. So imagine a situation, for instance, that you put geolocating tags on your delivery van so you can see when your delivery drivers are ahead of schedule or something like that. But imagine if those also reveal that they stop and have a pint every afternoon and then they drive half drunk, or if they stop and have an affair with the same person every day and waste a lot of time. Imagine if you then sack them for that bad behaviour, which is inappropriate in their role. Well, you've now used it for something that wasn't part of the original plan. And the geolocation is personal data because it allowed you to identify one individual. So that would be an inappropriate use of the data. It would be a data breach, depending on how you look at it. And when you sack them, you would probably then lose the legal action which followed when they said that they were unfairly dismissed. Data minimization says you must only keep as much data as you need and no more. So why would you keep extra data unless you actually have a specific role for it within the purpose that you've already identified? If you're just keeping it because one day it might be useful, then all you're doing is you're increasing the exposed data, increasing the risk to the data subject for no discernible benefit that you understood at the start. You have an obligation to try and keep it accurate. You certainly have an obligation to respond to the data subject's demands that you fix something if it's wrong. So if you've got the data wrong and they point it out to you, you need to update it. But you have an obligation to actually try and keep it accurate all on your own initiative as well. So you need to know probably how old the data is. If it's really, really old, maybe you need to be revisiting it to bring it up to date. Or alternatively, maybe stop using it. Storage limitation. Once you don't need it anymore, get rid of it. That's as simple as that. It's interesting, most people don't do that, but it's well worth figuring out which different data files you've got. Some of them you'll find you actually have no role for at all once they've fulfilled their initial purpose. I recently did an audit in a large PLC who had loads of psychometric tests on people who they'd had for interviews who hadn't got the job, and it was multiple years ago. So they had this in-depth insight into people's inner workings of their mind for people who weren't even employed. It doesn't make sense. And you have an obligation to maintain the integrity and confidentiality, and this is actually all to do with the integrity and confidentiality of the systems, really. So it's the security aspects of making sure the systems don't get hacked. It's also to do with making sure it stays available, in fact. So when the NHS's systems suddenly go down and all the data they needed to save people's lives is no longer available, that would actually be a breach of the integrity and confidentiality and availability rules in and around security. All of this has a much, much higher level of accountability. It's not a principle per se, but it's something that goes through everything in the act, like letter writing through a stick of rock. So the rights of the data subject. They have the right to access. This is a subject access request where they can ask you to show them all the data that you've got about them, and you're meant to produce it as quickly as you can. The right to be informed, so this is when you have to be overt with them about what data you're holding and why you want it and what you're doing with it. None of these rights, incidentally, are absolute rights. You can choose to say, no, this isn't fair, this isn't appropriate for us to tell the people this. The right to be informed, for instance, wouldn't necessarily be great if actually it was the police force spying on somebody who's committing crimes. They shouldn't be telling people that before they needed to. And so there are reasons why you might choose to ignore the right and put your other mission as a more important aspect. But you do need to be fairly sure about it because you might be answering for a judge about it later. The right to rectification, so this is correcting bad data, which there may be in your files if they come to learn of it. Often that would be through a subject access request. The right to object, so this is to say, stop, don't do it. It does what it says on the tin. You probably, certainly from a marketing point of view, as soon as somebody says stop marketing to me, stop marketing to them. You have absolutely no strength in legal basis for continuing to ignore them. You might, however, if you were a credit scoring agency, continue to keep their data even if they've asked to no longer be processed, because it's an important part of doing your role. But for marketing, you just don't have a strong enough case for that. The right to data portability is to do with people being able to get a better competitive products and offering from the digital marketplace. So it's the ability to take your banking history and move it to a new bank as seamlessly as possible to help the competition side and the chance for you to find a new provider. This could easily apply to telephone industry, for instance, moving from one handset provider to another. I have to say that's likely to come along in due course. At the moment, all they've said is put out the data in some sort of structured file like a CSV. In due course, it's likely to be the case that there'll be industry specialist formats so that a phone company can talk to a phone company in an easy way. There's a right to erasure, which on this instance is not a slightly dodgy 80s pop group. It's the right to have their data zapped. It was being called the right to be forgotten, but I think that got considered to be basically a little bit too ethereal, so they changed it to the right to erasure. Again, it's not an absolute right, but it's the idea is that somebody can disappear off of an unfortunate data listing that they don't want to be on. The right to restriction of processing. So this is, again, it's rather like the right to object. It's basically stop doing it. Stop doing it while we figure it out. Stop doing it while I argue with you about why the data is too sensitive for you to use in this way. And then the right not to be subject to fully automated decision making. So this might be somebody applying for a mortgage and the computer says no. Well, the computer can still say no, but they do have the right, enshrined within this act, to be able to demand to speak to a person and to be able to ask for an explanation about why the computer said no, and perhaps be able to put their own human-specific circumstance in such a way that that can be taken into account. The simple reality is, most of the time, that still won't fit in the computer, and the person who's on the phone to them will still end up saying, thank you. Okay, understood that. The answer's still no, and they'll read it off the computer screen. But at least they had the chance to pitch that to a person rather than a computer. Don't forget they can now receive compensation directly. So, I'm going to have to bring this to an end, and I regret that half an hour isn't enough to actually teach people GDPR. It really is only enough to lift the lid on it and to show that it matters. What I would say, though, is it really, really matters, and you do need to take it seriously. You don't need to panic, however. There is stuff you can do. So, prepare yourself now. You need to identify your data assets. What are the different databases that you actually have within your organisation, and how are they being used? You should be thinking about whether or not you need to use them. The first thing I'd suggest is if actually you no longer know what the hell it was for, delete it. Don't just do it without checking in case somebody else knows what it's for, but you might find that actually there's stuff which is just legacy and it's lying around and nobody really understands what it was for anymore. Why continue to expose those data subjects to that risk? Understand the processes that the data goes through from the point it's collected to the point it's used and eventually to the point it's deleted. Sometimes that'll throw up some interesting little question marks where you'll look at it and go, we shouldn't be that big, not really. Identify the risks that there might be to it, and figure out how bad the impact would be on the data subject if those risks came true and the data got leaked or abused or something. Because if actually there's a high risk that that data might be hacked or released into the wild, and it's got a catastrophic impact on the individual if it did, then you've got a situation there which is going to land you in a world of pain if it ever came true. You should be trying to reduce the chances that it would be leaked, and you should be trying to reduce the significance of a leak if it did happen. If there's a high risk to the subject, you'll need to do an impact assessment. That is very well laid out within the Act. There's about a whole page saying how you need to do that, and there'll be, I'm sure, more guidance coming along. But it is a very formal document you need to complete to say what you're doing and what the impact would be. And then you need to introduce appropriate controls. Now, appropriate controls is an interesting phrase. Because controls and security measures sometimes don't do the job you hope they're going to do. That roadblock, for instance, hasn't stopped that many vehicles transiting from A to B. And sometimes the controls that you thought were fantastic have found that the world has moved on and they're no longer quite as appropriate as they once were. So it's worth revisiting whatever controls you think you have in place already, because they may not be quite as fit for purpose as you believe. So specifically for you guys, the marketeers, since we're here, put suitable contracts in place between processors and controllers. You have to. It's in the Act. It says it's an absolute requirement. So if you've got a mailing house working for you, you have to have a written contract in place before you send them the data. Find out if the data ever leaves the EU. This is harder than it sounds. Don't forget there's cloud data and all sorts of things out there now, so there's all sorts of ways that it might be leaving the EU without you really being aware of it if you're putting it into some other processor. If your processor is outside the EU, think very hard about using a different processor. There may be a good case for carrying on using them, but it would have to be a damn good case because you're going to take on a lot more risk by sending it outside the EU. Check your opt-ins, satisfy the new consent rule. So if you're going to be relying on opt-ins and consent, and you quite probably will at some point for some aspects of your data, make sure they're fit for purpose with regard to the new consent stuff, because it has been toughened up quite a lot. Ensure that any prospecting data you acquire is compliant. You can't just trust this. Incidentally, this is how Corpdata makes its living from one day to the next. We supply marketing data. So if anybody, if you want that, you're just over there somewhere, I'd love to talk to you. So, however, if you are using prospect lists from outside, you have to make sure that it was gathered and put together in a way that's fit for you to put in your systems, or else you're just taking on board all of their bad practices into your risk matrix. And you most definitely need to document everything you've done and every sort of decision you've made so that you can explain it to a judge if you ever have to. Imagine it like health and safety. GDPR is coming. In fact, it's already here. It's already in UK law, it just doesn't yet have its fangs, but the teeth are coming too, and they're only about a year away. It's based on the Data Protection Act, but it's changed. It's changed in some small but cumulatively really important ways that makes it much more fierce. Actually, I have to say, much more useful for the role of data protection, but it does also give us the hurdle of trying to live up to those expectations, which are, and so cumulatively quite different. The risks to you as a company and a marketer within a company are you might be fined. You might look stupid or evil or something if you do it badly or wrong. Bad PR. You definitely find it harder to do marketing to new prospects because just the process of marketing to new prospects means you haven't got any buy-in yet, so you're going to need to find alternative ways of justifying that to that judge. And you will in fact lose the ability to market to some of your existing clients. The ICO guidance suggests that you can't rely on your previous relationship with somebody after 18 months if they haven't bought from you again. So 18 months after somebody buys from you, you should stop using their data and delete it. In practice, I think that's nonsense, and it will probably be rewritten in due course, because whilst that might make sense if you sell stationery, by the time they haven't rebought stationery from you for 18 months, probably your relationship's fallen apart. On the other hand, if you sell somebody cars or oil rigs, that's an entirely different duration of rapport, and I think probably 18 months is unrealistic to assume they're going to buy another oil rig. But that's the current guidance, and so you need to bear in mind that when you step outside of that, you're relying on being able to argue it to that judge. And you definitely need to document your processes, controls, contracts, terms and conditions, privacy policies, etc. One of the most important aspects of all of this is that you have to make sure your organisation is utterly fit in all regards. Technologically, you need firewalls and things, yes, but you also need to make sure all the staff who are interacting with data are suitably trained to do it properly. So there's the organisational and technological measures that are necessary to make sure it all works properly. Finally, don't panic. There is still enough time to make a significant step towards this, but you do have to make a start, and if you haven't already, you really do need to make a start now. This is a bigger job than it sounds. Perfect is the enemy of good. So in this instance, when you're standing in front of that judge and he says, why did it go wrong? And you end up saying, I couldn't be bothered to start. It seemed too difficult. You're going to be in a whole world of pain. If on the other hand you said, because we did this, and this, and I misread it, I got it wrong, you're likely to find a much more lenient judge who's able to help you change your processes and give you a mild slap on the wrist. Definitely don't be seen to be ignoring it. It's one of the things within the Act that they've said, if you ignore it, they'll come down on you harder. You need to document your planning to help prove you haven't ignored it. And finally, it is manageable, and if necessary, Corpdata and others can help you do it. You can call in outside consultants to help you get there. Just start looking at what you're already doing, and if you start getting panicky once you get into that, then start calling for help from wherever you need it. That's it. Thank you very much.